Good afternoon and welcome back. The second panel of the conference was devoted to the topic of the LAUTSI case and the margin of appreciation. Like my predecessor who moderated the first panel, I am not going to take up our valuable time with lengthy introductions of our distinguished panelists. Their bios are in your program. But on this panel we have Professor Monica Lugato from LUMSA Department of Law, Professor Marc Girolami from St. John's, and Professor Cole Durham from Brigham Young University Law School in the United States. And I will turn the podium over to Professor Lugato. We have an hour for this panel. I hope we have some time for questions at the end. Our panelists are going to do their very best to keep their speeches to within 20 minutes. So, Professor Lugato.
Thank you, Dean Simons. Let me just use 1 minute of the time that I'm allowed to for a word of welcome to our guests that have traveled a long way to be here, and to say how I feel a great degree of satisfaction for the conference that we are assisting to, that we're having, and that the organization of which has been a very challenging and at the same time, if I look around me today, rewarding experience. That being said, I will deliver my talk in Italian, being my mother tongue and the language of the institution to which I belong, and I'll count on the interpreters to allow everyone to share my few thoughts about margin of appreciation and the LAUTSI case. Comincerei, organizzerò le cose che devo dire chiarendo molto sinteticamente, dando qualche nozione sul margine di apprezzamento, che è una caratteristica diciamo tipica della giurisprudenza della Corte Europea dei diritti dell'uomo, vedendo che applicazione la Corte Europea ne ha fatto nel caso LAUTSI e proponendovi un paio di idee circa un aspetto che forse non è così esplorato, non è stato fino ad oggi così esplorato, del margine di apprezzamento, che è quello relativo al suo fondamento, alla sua possibile ricostruzione in chiave giuridica. In termini estremamente sintetici, ripeto, il margine di apprezzamento fa riferimento ad una area nella quale la Corte Europea dei diritti dell'uomo, oggi la Commissione Europea anche in precedenza, riconoscono e hanno stabilmente riconosciuto agli Stati contraenti della Convenzione una certa libertà quanto all'attuazione della Convenzione. È quindi uno spazio, secondo gli organi di Strasburgo, nel quale, nonostante i vincoli che gli Stati contraenti hanno assunto attraverso la Convenzione, rimane uno spazio di scelta agli Stati contraenti circa le modalità con le quali sono autorizzati a dare attuazione ai diritti previsti nella Convenzione, o, se vogliamo guardarla dall'altro lato, a dare esecuzione ai propri obblighi. Ora, la sfera di applicazione del margine di apprezzamento, che è un aspetto su cui del quale in dottrina ci si è occupati molto, è sintetizzabile nei termini seguenti. Non c'è margine di apprezzamento nell'area dei diritti assoluti che la Convenzione europea impone. Pensiamo per esempio al divieto della tortura, pensiamo al divieto della schiavitù. C'è invece il margine di apprezzamento viene invece riconosciuto originariamente quanto all'applicazione dell'articolo 15 della Convenzione Europea dei diritti dell'uomo relativo alle deroghe ai diritti protetti, cioè a situazioni nelle quali la Convenzione ammette che gli Stati contraenti possano, a determinate condizioni, derogare ai loro obblighi in base alla Convenzione. È stato poi riconosciuto il margine di apprezzamento degli Stati nella sfera della limitazione, delle restrizioni ai diritti protetti dalla Convenzione, anch'esse ammissibili con riferimento a una ampia serie dei diritti protetti dalla Convenzione, naturalmente esclusi i diritti assoluti. E tra questi diritti che sono limitabili in base alla Convenzione c'è anche il diritto alla libertà religiosa di cui ci occupiamo oggi. Quindi l'applicazione delle clausole permettono la restrizione, la limitazione dei diritti protetti è un'altra delle sfere nelle quali il margine di apprezzamento ha avuto ampia applicazione. Quello che però ci interessa di più oggi è l'uso che la Corte europea fa del margine di apprezzamento quando si tratta di valutare il comportamento dello Stato rispetto ad alcuni diritti che la Convenzione definisce con regole che sono state definite in maniera abbastanza efficace open-ended, delle quali si è detto che esse forniscono soltanto un limitato orientamento alla condotta degli Stati. In italiano diremmo regole aperte, regole indeterminate. Quindi quando la Convenzione europea si riferisca a diritti il cui contenuto non è precisamente determinato, lì la Corte europea ha ravvisato lo spazio, uno spazio discrezionale, è stato detto, direi più uno spazio di autodeterminazione nell'attuazione di questi diritti per gli Stati contraenti. Qual è la ratio del margine di apprezzamento? Sempre guardando a come essa può essere ricostruita partendo dalla casistica. L'idea sottostante è che ci sono aspetti della tutela dei diritti umani, e questo particolarmente in materia di diritto all'istruzione e di diritto alla libertà religiosa, ci sono aspetti rispetto ai quali autorità nazionali di carattere democratico sono, la Corte dice, meglio posizionate rispetto al giudice internazionale, noi diremmo hanno una maggiore legittimazione rispetto al giudice nazionale per configurare le politiche nazionali, per assumere le decisioni interne anche relativamente all'attuazione dei diritti protetti dalla Convenzione europea dei diritti dell'uomo. Inoltre ci sono disomogeneità fra gli Stati contraenti. Non esiste riguardo a tutti i diritti protetti dalla Convenzione un approccio europeo comune e quindi in questi casi deve essere lasciato agli Stati contraenti, dice la Corte europea, la libertà di organizzare, regolare ed eventualmente restringere i diritti e le libertà in questioni sotto il controllo della Corte europea dei diritti dell'uomo, quindi con il limite della supervisione da parte della Corte europea rispetto a come lo Stato esercita questo margine di apprezzamento e in un giudizio però la Corte europea aggiunge anche, ed è un dato importante, che deve essere necessariamente casistico, contestuale. Cioè questi casi vanno valutati da parte della Corte europea in sede di verifica, di controllo del comportamento dello Stato, tenendo un approccio che tenga nella debita considerazione le specifiche condizioni di ogni Stato. Naturalmente il margine di apprezzamento ha attratto critiche e approvazione, come tutte le cose. I critici lo considerano soprattutto come una indebita deferenza che la Corte europea esprime nei confronti della sovranità degli Stati contraenti, che sarebbe destituita di qualsiasi fondamento in base alla Convenzione e che sarebbe strumentalmente diretta a preservare il consenso degli Stati contraenti nei confronti della stessa Corte europea. Inoltre fanno valere una critica di ordine più strutturale. Si tratta di una idea, quella del margine di apprezzamento, di una dottrina, come viene generalmente definita, che sarebbe intrinsecamente incompatibile con la protezione dei diritti umani, in quanto lo scopo delle norme sui diritti umani è quello di proteggere i diritti individuali contro lo Stato, non di tutelare spazi di discrezionalità a carico dello Stato. L'ultima critica è che la Corte sarebbe inconsistent nell'applicazione del margine di apprezzamento e i parametri di riferimento sarebbero imprecisi. Coloro che difendono invece il margine di apprezzamento fanno valere che da un punto di vista oggettivo, se ad una norma, ad un diritto protetto dalla Convenzione europea non è ascrivibile un significato oggettivo, non spetta alla Corte attribuirglielo, ma è bene deferire alla valutazione degli Stati contraenti e considerano il margine di apprezzamento come un essenziale strumento addirittura di carattere costituzionale, come si usa dire, per la difesa del pluralismo dei valori che contraddistingue l'Europa e le società europee. Dicevo però che sull'aspetto del fondamento del margine di apprezzamento c'è meno chiarezza, ed è qui che mi piacerebbe proporre un paio di possibili punti di riferimento per la valutazione circa la fondatezza di questa idea nel sistema della Convenzione europea dei diritti dell'uomo. Prima di proporvi questo paio di idee, dico brevissimamente che uso la Corte europea dei diritti dell'uomo ha fatto nel caso LAUTSI. Mi riferisco alla Grande Chambre, alla Grande Camera, perché, come tutti sapete, nella sentenza del 2009 non c'è stata alcuna menzione da parte della Corte europea dei diritti della Camera della Corte europea del margine di apprezzamento. Dunque, nel caso LAUTSI, trovo che sia importante sottolineare, del resto la Corte lo fa, la Grande Camera lo fa nella sua decisione, che la Corte era chiamata ad accertare se l'esposizione esponendo il crocifisso nelle aule scolastiche l'Italia avesse violato l'articolo 2 paragrafo 1, quindi il diritto dei genitori ad un'istruzione rispettosa delle loro convinzioni religiose e filosofiche, insieme all'articolo 9, letto insieme all'articolo 9, cioè al diritto, alla norma che protegge la libertà religiosa. La Corte europea dei diritti dell'uomo afferma che, la Grande Camera della Corte europea afferma che l'obbligo di rispettare le convinzioni religiose e filosofiche dei genitori nel momento in cui esercita le sue funzioni nel campo dell'educazione, dell'istruzione, impone allo Stato di astenersi dall'indottrinamento e dal proselitismo. Quindi dall'articolo 2 paragrafo 1 cosa viene fuori? Viene fuori un obbligo a carico dello Stato di astenersi da indottrinare o dal tenere attività diciamo di proselitismo e di assicurare, questo è l'altro obbligo, una istruzione che sia imparziale, critica e pluralista. D'altra parte, dice la Corte europea, l'articolo 9 pone un obbligo di assicurare agli Stati contraenti, a tutte le persone, pone un obbligo agli Stati contraenti di assicurare a tutti coloro che sono sottoposti alla propria giurisdizione il diritto di avere o non avere una religione, di manifestare la propria religione, e il divieto di richiedere atti di osservanza di una qualsiasi religione. Lo Stato dice la Corte europea, deve essere un arbitro imparziale del pacifico dispiegamento delle varie convinzioni religiose e deve quindi osservare, tenere un comportamento neutro ed imparziale. La conclusione che la Corte trae da questo esame dell'articolo 2 del protocollo 1 e dell'articolo 9 è che, siccome l'esposizione del crocifisso non è indottrinante e non costringe ad alcun atto o comportamento di osservanza della fede, in questo caso cattolica, essa non è in sé per sé incompatibile con la Convenzione europea. Nemmeno il fatto che inevitabilmente attribuisce una visibilità preponderante alla religione cattolica è in sé per sé contrario alla Convenzione europea dei diritti dell'uomo, perché questa esposizione va valutata in un contesto, nello specifico contesto italiano, nel quale la neutralità dello Stato rispetto alle religioni e il rispetto delle convinzioni dei genitori nell'esercizio delle funzioni legate alle istruzioni vengono assicurati attraverso l'organizzazione complessivamente considerata dell'istruzione. Quindi, cose che sono state menzionate stamattina, è stato dimostrato davanti alla Corte che c'è un'apertura alle varie religioni che, diciamo, in qualche modo fa da contrappeso rispetto alla esposizione, la Corte dice, passiva del crocifisso, mentre dal punto di vista dell'apertura dell'ambiente scolastico, dell'insegnamento, dei contenuti dei programmi, è garantita l'apertura alle varie religioni. La conclusione, quindi, sul piano del problema dei singoli religiosi è che lo Stato ha, rispetto a questo specifico aspetto del diritto all'istruzione e del diritto alla libertà religiosa, un margine di apprezzamento, quindi una area di di scelta nella quale può definire le regole relative all'esposizione dei simboli religiosi. Bene. Vi propongo di guardare a questo iter argomentativo e di porci la domanda: è fondato o non è fondato sulla Convenzione europea dei diritti dell'uomo, partendo dalle regole sull'interpretazione dei trattati. E le regole sull'interpretazione dei trattati, le regole internazionali sull'interpretazione dei trattati sono codificate nella Convenzione di Vienna del 69 e sono regole che la Corte europea dei diritti dell'uomo è tenuta a seguire, in quanto regole internazionali applicabili a tutti i trattati internazionali, compresa quindi la Convenzione europea. Non solo, ma che la Corte europea ha, in una giurisprudenza consolidata, ripetutamente riconosciuto di osservare, a partire dal famoso leading case Golder contro Regno Unito di un certo numero di anni fa. Ora, che cosa stabiliscono queste regole? I trattati internazionali devono essere interpretati in buona fede, sulla base del significato ordinario dei termini contenuti nel loro testo, alla luce del loro oggetto e del loro scopo e nel loro contesto. E la Convenzione definisce il contesto mettendo assieme una serie di elementi che compongono il contesto, il preambolo e gli allegati dell'accordo, eventuali accordi o strumenti di altra natura che gli Stati contraenti abbiano concluso al momento, abbiano stipulato al momento della conclusione del trattato, accordi successivi che siano stati stipulati fra tutte le parti in relazione all'interpretazione o applicazione del trattato e significativamente qualsiasi prassi che gli Stati contraenti abbiano seguito nella applicazione del trattato successivamente alla sua entrata in vigore, a condizione che da quella prassi, questo è un elemento importante, si possa evincere un accordo fra tutti gli Stati contraenti relativo alla sua interpretazione. Ora, il testo della Convenzione e anche quello dei protocolli non stabiliscono, non si riferiscono specificamente, non si occupano del problema dell'esposizione dei simboli e la Corte sottolinea che sia l'articolo 2 protocollo 1 che l'articolo 9 si incentrano su nozioni che hanno carattere multiforme, il rispetto. L'obbligo di rispettare non è oggettivabile in un comportamento univoco, ma può essere attuato in vari modi e la stessa neutralità è un concetto, l'abbiamo sentito più volte stamattina, che è suscettibile di essere riempito con vari significati. In mancanza di indicazioni ricavabili, quindi espresse, ricavabili dal testo della Convenzione, la Corte europea cosa fa? Va a cercare se per caso, in ordine al rispetto, in ordine alla neutralità, esista una visione comune fra gli Stati europei contraenti della Convenzione europea e conclude, come tutti sapete, che there is no European consensus on the question of the presence of religious symbols in state schools. Il punto è: a che titolo l'esistenza di questo consenso europeo orienta la decisione della Corte? Perché la Corte va a fare riferimento? Sulla base di quale titolo, appunto? E a questo riguardo si devono ricordare due cose. La Convenzione europea è un living instrument, dice la Corte europea dei diritti dell'uomo, e quindi è una convenzione che deve essere interpretata tenendo conto degli effetti che su di essa produce il passaggio del tempo, il mutare delle circostanze. Se teniamo conto di questo, allora, e abbiamo visto che la regola sull'interpretazione dei trattati ci dice la stessa cosa, pone lo stesso obbligo, ci indica una serie di elementi che consentono, anzi impongono all'interprete di interpretare un trattato internazionale tenendo conto del passaggio del tempo. Allora, il fatto che la Corte attribuisca un significativo peso al consenso europeo può essere letto alla luce delle indicazioni che vengono dalle regole sull'interpretazione dei trattati. La subsequent share practice che gli Stati contraenti hanno seguito nell'applicazione della Convenzione europea dei diritti dell'uomo è precisamente il veicolo attraverso il quale può maturare e si esplicita il consenso delle parti contraenti circa obblighi che non siano espressamente previsti dalla Convenzione, ma che si nascondono in un certo senso in disposizioni della Convenzione che hanno un carattere aperto e indeterminato e quindi che si prestano a concretizzazione progressiva, coerentemente con il mutare delle condizioni politiche, economiche e sociali e coerentemente anche, questo mi sembra un altro punto importante, con l'affinarsi della sensibilità circa la protezione dei diritti umani, che è un fenomeno storico, è un fenomeno sociale e quindi anche un fenomeno giuridico inarrestabile e che impone anzi che rivela sempre nuove frontiere. Allora, questo è un punto che non è stato sufficientemente osservato dai commentatori e che mi pare che ancori l'uso che la Corte fa del margine di apprezzamento ad un criterio obiettivo. Qualcuno ha detto tutto sommato il consenso europeo è un criterio obiettivo, ma nessuno ha fatto il passaggio di ricollegare questo approccio della Corte europea alle regole sull'interpretazione dei trattati, che rappresentano la casa comune in materia di interpretazione dei trattati internazionali. Dunque il riferimento al consenso europeo non è un vago e impreciso capriccio o atteggiamento creativo da parte della Convenzione della Corte europea dei diritti dell'uomo, ma è una applicazione alla Convenzione europea delle regole generali sull'interpretazione dei trattati. Ho esaurito il mio tempo, ma chiedo venia se aggiungo una considerazione in termini di mero accenno. Era la seconda considerazione che volevo proporvi, ed è questa. Il margine di apprezzamento va necessariamente valutato alla luce di una caratteristica intrinseca della Convenzione europea, della sua specifica natura, così come quella natura è stata identificata ripetutamente in maniera consolidata dalla Corte europea. La Convenzione europea dei diritti dell'uomo ha natura sussidiaria e il margine di apprezzamento è un corollario logico della natura sussidiaria della Convenzione. Se prendiamo molto rapidamente la dichiarazione di Brighton del maggio 2012, resa dalla conferenza di alto livello sul futuro della Convenzione europea dei diritti dell'uomo, in quella dichiarazione si esplicita il collegamento, il nesso logico che c'è fra sussidiarietà e margine di apprezzamento. La giurisprudenza della Corte rende chiaro, dice la conferenza di alto livello, che gli Stati contraenti godono di un margine di apprezzamento nell'attuazione della Convenzione europea che dipende dalle circostanze del caso e dalla tipologia dei diritti e delle libertà in questione, e questo riflette il fatto che il sistema della Convenzione europea è sussidiario rispetto alla protezione nazionale dei diritti dell'uomo. Mi ricollego in parte a cose che sono state dette anche questa mattina. Evidenti ragioni, consentitemi di dire, di prossimità e di legittimazione democratica depongono a favore di questa articolazione dei rapporti fra protezione nazionale e protezione internazionale dei diritti dell'uomo, per cui è legittimo che resti nella sfera decisionale dello Stato, delle collettività nazionali delle quali esso è espressione, la determinazione di come i diritti fondamentali delle persone vanno assicurati in armonia con le specifiche circostanze locali che derivano dalla particolare fisionomia che ciascuno Stato ha acquisito attraverso il suo percorso storico, culturale, antropologico, eccetera, eccetera. Qual è il limite? Il controllo esterno essenziale da parte della Corte europea dei diritti dell'uomo e gli obblighi posti dalla Convenzione, quindi il margine di apprezzamento dello Stato si dispiega all'interno dei confini che sono delineati dagli obblighi della Convenzione quando questi siano suscettibili di una sufficientemente precisa identificazione. Un ultimo caveat: il margine di apprezzamento è, così come la protezione dei diritti umani, così come la Convenzione europea, ha carattere dinamico evolutivo. Quindi cosa significa? Che è un concetto relativo. Quello che oggi rientra nel margine di apprezzamento potrebbe non rientrarvi domani, o perché gli Stati contraenti, gli Stati europei, decidano che nuovi diritti meritano protezione, lo fanno attraverso i protocolli aggiuntivi, oppure perché appunto maturi nelle varie società nazionali una nuova comprensione, una nuova percezione di quali siano i diritti che vanno ricondotti all'interno di quelle espressioni in parte indeterminate che la Convenzione europea contiene. Bene, conclusione. Il margine di apprezzamento è riconducibile alle regole sull'interpretazione dei trattati e trova una sua configurazione alla luce della natura sussidiaria della Convenzione europea dei diritti dell'uomo, attraverso la quale assume una propria più oggettiva, più precisa fisionomia. La responsabilità della fissazione degli standard comuni di osservanza dei diritti umani non è della Corte europea dei diritti dell'uomo, è degli Stati contraenti e delle collettività nazionali che si esprimono attraverso il progressivo sviluppo di quel testo adottato nel 1950 che è la Convenzione europea dei diritti dell'uomo. Grazie mille.
Thank you, Professor Lugato. Professor Di Girolami?
I'm going to speak from here as I have a little PowerPoint for you. Ma vorrei prima ringraziare il professor Angelo Rinella, la professoressa Monica Lugato e alla Università LUMSA per aver organizzato questo convegno nel quale per me è un gran piacere partecipare. Sfortunatamente il mio italiano non è sufficientemente sviluppato per poter fare tutta una presentazione in italiano, allora purtroppo dovrò procedere in inglese. So, with that said, my talk, which is entitled The Conciliations of History, will proceed in 3 stages. First, I'll talk a little bit about the importance of judicial or jurisprudential methodology in thinking about religious displays. I will describe a shift in European and American decision-making away from adherence to abstract philosophical ideals and toward a more culturally and historically informed analysis. Second, I will offer an explanation for this shift, the inevitability of what I'll call tragic choice among conflicting values that these disputes implicate, and the inability of a single value or principle to make sense of these conflicts. Third, if abstract principles are increasingly unhelpful to courts in deciding these cases, one might wonder what is or what ought to be helpful to them. And here I have a couple of themes or ideas which I think are emerging. The first idea, which is increasingly appearing, is reliance on local cultural history as jurisprudentially meaningful in the effort to conciliate conflict. And it's at this point where I'm going to talk a little bit about the idea of the margin of appreciation. And the second theme is courts' increasing and, in my view, healthy affirmation of the interpenetration of culture and religion alongside a reluctance to take it upon themselves to keep each category, the religious and the cultural, conceptually pure. So first, a word on methodology. In thinking about this corner of the law, the prevailing methodological approach to questions of religious liberty has been to proceed as a kind of quest to achieve or inculcate a single predetermined value. In the United States, that value is sometimes claimed to be neutrality or sometimes equality. In the past, it was claimed to be the separation of church and state. Some theorists today claim that equal respect is the value, but there are many other possibilities. What is emerging, I think, in both the LAUTSI case and in some of the more recent American cross cases, for example, is a shift from thinking about these controversies by recourse to a single value or even by recourse to a set of values like equality and autonomy, and toward a more holistic consideration of a suite of values alongside highly particularized factual assessments. Second issue, why is this shift occurring? Well, I missed that slide, so you'll have to just jump in here to the third slide. Why is this shift occurring? Again, a shift away from philosophical system and toward thematic, particularistic, and holistic assessment. There are probably several explanations for why the shift is occurring, but one which seems plausible to me is that values like neutrality or equality or respect, considered in isolation, are simply not up to the task of resolving these conflicts in a satisfying way. Religious liberty disputes often implicate a great many clashing values, and we tend to care about preserving all of them. And there doesn't seem to be any single scale of worth, single scale of assessment by which we can rank order their importance systematically and across all categories of case. Consider, for example, the European Court of Human Rights rule that member states must act neutrally and impartially in ensuring that believers and non-believers are able to coexist harmoniously within democratic society. Or consider instead the rule that the religious and philosophical wishes of parents must be respected. How was the court in LAUTSI to decide the case by recourse to the abstract idea of neutrality or universal respect? Removal of the crucifix would indicate to Catholics that their religious tradition is being disrespected and disvalued. Retention of the crucifix would indicate to non-Catholics that their beliefs are being disrespected and disvalued. Neither choice is a neutral one. To the contrary, both decisions are non-neutral, both are partial, and both will properly be perceived that way. No master theory or principle, not neutrality, not respect, not equality, and not any other, can reconcile these conflicts of values systematically and across all cases. Whichever value triumphs in any particular dispute will create a sense of remainder and regret for the value that was lost. And that remainder and regret is important because it represents our collective, real commitment to a value that has been damaged. That is why framing the discussion of these conflicts in terms of an overarching philosophical abstraction like neutrality is unsatisfying, and it is also why, increasingly, I believe, courts are opting for a different kind of approach. So, to the third point, what is replacing abstracted systematic philosophical principle as a reference point for judging? First, I believe that an examination of local, cultural, case-specific history is becoming a valuable instrument for conciliating the clash of values. Naturally, it's not the only jurisprudential metric, and in certain appropriate cases, these sorts of considerations can be overridden by other kinds of considerations. But consideration of cultural history is nevertheless becoming a crucial modality of argument and of decision-making. In LAUTSI, for example, the court reviewed extensively the historical roots of Italy's domestic practice with respect to the display of the crucifix in public school classrooms. The crucifix, of course, is a symbol of ancient religious, cultural, and educational importance to Italians. The practice of displaying the crucifix, as many of you will know, in public school classrooms first began as a risorgimento phenomenon, and later during the early years of Italy's national formation, the continued hanging of crucifixes in classrooms was the product of a compromise between certain secular forces and certain religious forces. And I want to emphasize the fact of compromise, a religious, political, legal, and cultural conciliation between avowedly secular and religious worldviews, both of which were responsible for founding a nation composed of highly disparate and fragmented components. Still later, during Italy's fascist period, beginning in the 1920s, the government again promoted the practice of displaying the crucifix, and ultimately, the Court of Human Rights, European Court of Human Rights, concluded that while the crucifix is undoubtedly a religious symbol, and while all member states are obliged to ensure that curricular instruction is imparted in an objective, critical, and pluralistic fashion, display of the crucifix didn't violate commitment to neutrality. But how? How was the court able to reach that conclusion? Only by contextualizing the values of neutrality and respect in light of Italy's particular cultural history. cultural and historical context have also played an increasingly important role in American Establishment Clause decisions. I could select several examples, but the most straightforward one is Elk Grove Unified School District versus Newdow, which Professor Berg mentioned a little bit earlier in his remarks, in which the Supreme Court was faced with an Establishment Clause challenge to the words "under God" in the Pledge of Allegiance, as recited voluntarily by public school students in the state of California. The pledge was written in 1892 to commemorate the 400th anniversary of Christopher Columbus's discovery of America, and as Professor Berg mentioned, for the first 62 years of its existence, it did not contain the words "under God." And in 1952, Congress introduced "under God" to recognize that, quote, "From the time of our earliest history, our peoples and our institutions have reflected the traditional concept that our nation was founded on a fundamental belief in God," close quote. And "under God" has remained a part of the pledge ever since. Opponents of "under God" made arguments startlingly similar to the claims made in the LAUTSI litigation. In LAUTSI, objectors to the crucifix were quick to argue that display was solely the product of a shameful and thoroughly discredited fascist moment. But surely that criticism is not the product of a reasonable memory. The prior history of the practice, reflecting the types of civic compromises vital to Italy's formation, as well as the much older and deeper connections between Christianity and Italian cultural history, were not remembered. In very much the same fashion, opponents of "under God" in the pledge often emphasized its inclusion by Congress in the 50s as of a piece with the intensely anti-communist ethos of that time, with its attendant McCarthyism. Even though Elk Grove was ultimately dismissed on a technical ground, Chief Justice Rehnquist's concurrence, it seems to me, better developed the cultural history of the phrase "under God" in civic pronouncements that are central to the American sense of national culture and identity, because, not in spite of, their religious roots. Public and, quote, "patriotic invocations of God and official acknowledgments of religion's role in the nation's history abound," the Chief Justice said, from George Washington's acknowledgement of Almighty God in his first Thanksgiving proclamation to Abraham Lincoln's famous and celebrated use of the phrase "under God" in the Gettysburg Address, to the official pronouncements of many presidents since. The phrase "in God we trust," which appears on the front of our program, on the coinage, which first appeared during the American Civil War, the opening exhortation of the Supreme Court's Marshal, "God save the United States and this honorable court," quote, "all of these events," wrote the Chief Justice, "strongly suggest that our national culture allows public recognition of our nation's religious history and character," close quote. Now, it is true that as time has passed, the country has become more religiously pluralistic. But the fact that reasonable disagreement exists about the quality of these public, religiously rooted expressions does not distinguish America's present from its past. Cultural history, in sum, offers more than a political reason for leaving the crucifix on the wall or for leaving the phrase "under God" in the pledge. Where a legislative body has made the choice to preserve a practice with pervasive, unambiguous, and long-standing historical connections, and ones which, as a result of that cultural history, are deeply embedded in popular practice and feeling, courts should be leery, not implacably opposed, but reticent to disturb that decision in favor of the inculcation of a single value. The reason isn't that cultural histories are always inherently worth preserving, or that democracies always make the right choices, but that cultural history and the doctrine that is addressed to it makes sense of a dispute which pits otherwise intractable, clashing values of religious liberty. Now, the second development that I want to note is the increasing recognition of the interpenetration of religion and culture. And this is a theme that Professor Ferrari, Professor Cardia sounded this morning, and I'm going to sound it again. In certain areas of conflict, it is impossible and unprofitable to maintain the conceptual purity of the religious and the cultural, or to assess authoritatively the relative strength of a symbol's different reasonable meanings. An American Supreme Court court case which brings this quality particularly vividly out involved the permissibility of displaying a 5-foot high white cross which had been placed in the Mojave Desert in 1934 by a group of veterans to honor the memory of American soldiers who died in World War I. The cross had stood for nearly 7 decades, where it served as a site for both Christian celebrations and civic and military remembrances. And in 2001, a retired Park Service employee complained of the cross's presence on federal land. Now, the case was complicated by questions of ownership of the land, but for my purposes, what I want to focus on is the capacity of a court to assess the cross's legal meaning. Just as context was useful in LAUTSI, so it was in this case, in Salazar versus Buono. Justice Alito's concurrence identified, having reviewed the relevant history of this litigation, 2 reasonable meanings: the original Christian meaning as a marker of the resurrection, and a civic meaning intended to commemorate the war dead. Now, in dissent, Justice Stevens, John Paul Stevens, countered that the cross, quote, necessarily symbolizes an inescapably sectarian message, close quote, so any additional meaning was tainted. He said, making a plain, unadorned Latin cross a war memorial does not make the cross secular. It makes the war memorial sectarian. In this respect, at least, I think Justice Stevens is right. The cross's military commemorative meaning is not a culturally detached meaning that just happened to arise second in time. It is connected to the Christian meaning in this more substantively temporal and causal sense. Had there been no prior Christian meaning, there would also be no tradition out of which subsequent military commemorative meanings could arise. A symbol may acquire multiple reasonable meanings across its history. And so the question becomes, is the substantive, temporal, and causal connection between a symbol's religious and other reasonable meanings sufficient to forbid the state from recognizing the symbol as part of its civic and cultural life? And to that, I say, it hardly seems to be the case. Right? As Justice Stevens himself noted, context is critical to the Establishment Clause inquiry. And any judgment about the cross's meaning which assigns a monolithic, unalterable master meaning betrays an inattention to those historical circumstances in which different reasonable meanings may arise. And I should also say, it is exceptionally difficult to tease out and isolate which meanings of a symbol are purely religious and which are purely secular, to know what it is precisely that the veterans intended to commemorate when they erected the cross, and what subsequent generations of onlookers have understood. Consider several plausible meanings, all of which are variations on the cross's civic commemorative meaning, and many of which depend to some degree on the temporal and causal priority of the Christian meaning. A remembrance of the sacrifice for the greater good, a tribute to the military life, an acknowledgement of lives lived honorably or nobly, a token of civic unity, an emblem of goodwill, a monument to the transience of life and to the world that lies beyond it, a marker of the transcendent coming into contact with the time-bound and earthly. It seems a kind of willful denial of the interpenetration of culture and religion to hold that these sub-meanings are categorically illegitimate simply because they bear a temporal and causal connection with a religious meaning which, as a matter of cultural history, cannot be entirely disentangled from it. Now, one might argue that these subsequent meanings have only arisen because many people were or are ignorant of the original religious meaning. If they had been aware of that meaning, new civic sub-meanings would not have arisen. That seems highly implausible to me. Consider the motto of Harvard University. Harvard University's motto is Veritas, truth. An original version of the seal, adopted in 1692, was Veritas, Christo et Ecclesiae, truth for Christ and the Church, chosen, among other reasons, to honor the college's primary function of training Christian ministers. And I have to point this out. You will notice 3 books on the red part of the seal, right, as represented with ver, re, and tas. You will notice that 2 of those books are face up, and the third is face down. The idea being some knowledge is hidden from us and for God alone. And in fact, the 1780 Constitution of Massachusetts specifically describes Harvard College as an institution where, quote, the encouragement of arts and sciences and all good literature tends to the honor of God, the advantage of the Christian religion, and the great benefit of this and the other United States of America. Now, at some point, the decision was made to drop the last 3 words, the last 3 words of the motto. And the motto is now known as Veritas alone. You will also notice that the third book is no longer face down, it is face up, and I will let you draw whatever inferences about cultural and social history you wish. But the point is that independent, reasonable meanings have arisen as a result of that change, even though those meanings are temporally and causally connected to the motto's original religious meaning. Now, it is true that unlike the early Harvard motto, the cross's original religious meaning is still vital. But the point is simply that these reasonable subsequent meanings can arise from many sorts of historical reasons that do not depend upon popular ignorance. And it is fruitless to attempt to tweeze away the cross's civic sub-meanings from an antecedent religious meaning. Religious and cultural meanings can and do interpenetrate across time. So just to sum up quickly, these new jurisprudential methodological moves, the turning away from general and abstract philosophical ideals and toward particular local cultural histories, alongside the recognition that culture and religion often interpenetrate, represent, in my view, healthy developments in the law of state-sponsored religious symbols. Thank you.
We have managed to save just 20 minutes for Professor Durham, so the floor is yours.
Thank you very much. I think this is picking up. I'd like also to express my appreciation to the organizers and to express appreciation for what is always marvelous Italian hospitality. In talking about a margin of appreciation, I couldn't help thinking last night that I was hopeful that in this European setting that I would personally be given some margin of appreciation, even though I know from experience that I benefit from European supervision by people like Silvio Ferrari and others. LAUTSI is about one of the most significant symbols in the history of world religion. But it is more than that. The case itself has become a symbol of the larger debate in all our societies about the extent to which a man can bring religious symbols into public settings. More generally, it's about the place of religion in public order of contemporary political societies. And at a more technical level, there's a question about how the European Court of Human Rights should respond to such issues. After the Grand Chamber decision in LAUTSI, are we in a situation in which margin of appreciation has simply swallowed up all decisions of principle in this area, or is there more than deference to powerful member states and to subsidiarity and to sovereignty involved? I think one of the worries in this area is that the answer to that question depends on the kinds of secularism or secularity that we view as providing the framework for our answer. I was conscious a few years ago, a friend of mine, Ingvild Plesner from Norway, identified the phrase or the contrast between liberal and fundamentalist secularisms. We usually don't think about fundamentalist secularisms, but I think that that is potentially an issue. What kind of secularism do we choose? And cases like LAUTSI, they're not only about symbols, they symbolize our answer. Now, this highlights the issue that all societies face at the unfolding edge of history. How should our states respond to the realities of religious difference in our midst? One possibility is to move back in the direction of heightened identification with a particular religion. I spent much of this week in Russia, where that seems to be a direction that things are moving back, trying to reclaim the past, but reclaiming it in a way that excludes space for others. Now, this can be a very tempting political move, particularly when a large percentage of the population identifies with a particular religion. But if there's anything that history has taught us, it is that this type of arrangement poses grave risks for all but those in the majority, and it places the majority's co-religionists at risk in other countries where they lack majority standing. In our more highly pluralized day, this is likely to result in even greater discrimination and persecution than it did in the past. The same reasoning, however, raises questions about moving too far in the direction of identifying with secularism as an ideology. When secularism becomes an ideological position, committed to promoting a secular state as an end in itself, with the aim of liberating believers from religion, becomes just one more comprehensive worldview, and it is as dangerous to attempt to impose it on all the members of society as it is to impose traditional religion. In some ways, it may be even more dangerous because pursuing this type of agenda is particularly likely to ignite a religious backlash. What I think we need is a commitment to an authentically pluralistic mode of secularity which avoids identification of the state with any particular religion or ideology, including secularism itself. What is needed is a governmental framework capable of accommodating or cooperating with a broad range of religions or beliefs and capable of communicating that within broad limits, that all are welcome and the conscientious claims of all will be afforded strong protection, subject to the narrow limitations that are typically articulated in international instruments and national constitutions. Different societies can implement such pluralistic secularity in different ways, but in the long run, across a wide range of issues, pluralistic secularity is more likely than confessionalism on the one hand or rigid secularism on the other hand to protect human dignity, to protect the appropriate space for freedom of conscience, and to promote many other social goods that are linked to protection of freedom of religion or belief. So let me just turn. What I want to do in the remainder of my time is just focus on some issues and some ways of thinking about this issue of what kind of secularism, what kind of neutrality do we want. I think one of the things that was right about LAUTSI is recognizing that neutrality does not equal secularism, or there are many neutralities corresponding to many different kinds of secularism. Now, let me speak to some experiences. I remember early in the 90s, I had an opportunity as the Secretary of the American Society of Comparative Law to be working with a lot of the emerging regimes in Eastern Europe, and often on religion issues. And I remember going to these countries, and I would have a dialogue that would go like this. They would say, well, it's nice what you're talking about, but you're an American. We have a prevailing religion here, and we need to have that be treated specially and so forth, and that has various kinds of legal implications. Now, what was interesting to me is at that same time I was involved in some litigation in my home state of Utah, which is the only American state that really has a majority religion. Rhode Island has 52% Catholic, but Utah is 70% Mormon. And the issue was about city council prayer, whether it should be permitted, and the case hinged on a very extreme interpretation of the Utah state constitution, which said no state funds can be appropriated to fund any religious exercise. And the argument was there was some electricity in the microphone that was being used for the prayer at the city councils, and so this was an appropriation of funds, and therefore it was impermissible. Well, if you took that kind of rationale, it was going to be impossible to have crosses in cemeteries because the lawns were mowed by the state, and I mean, there were just all kinds of problems. So I got involved in working against this. Now, what was striking to me was the conversations I had, very much almost like the European conversations I was having concurrently. I'd go back and forth. And they would say, we have a majority religion here. That means we need special protection for the minorities. And I thought that argument was right. I mean, I think more generally, it's important to understand that both majorities and minorities can feel threatened. And what is vital in a pluralistic society is to develop constitutional protections that protect everyone. That's what an ideal form of secularity will bring. Now, let me say some things about margin of appreciation. And I hope this will be in the spirit of adding and supplementing what Professor Lugato has said. I think there are a number of reasons why margin of appreciation is indeed important, particularly in areas where there isn't consensus. There are many areas where we can have constitutional values that can be implemented in a variety of different ways. And one of the in our federal system in the United States, one of the in this type of area, we don't talk about margin of appreciation. We just talk about federalism and the importance of being able to have a laboratory where different ideas can be tested. One of the things, on the one hand, this can reflect different traditional answers in different parts of the country to an issue, but it also opens up possibilities of trying new things. Now, it's clear also that you need to have some kind of floor. Sometimes you can talk, not all traditions are good. I will sometimes talk with my students when they will start talking about how sort of the dominant views should be given respect, and I'll say, yes, we should respect sort of the healthy sensitivity of the people, right? And then I remind them that that was the Nazi slogan for protecting the healthy Aryan traditions, and that sort of undermines the credibility of that. The point is, well, there are good traditions, there are bad traditions. We need to have we need margin of appreciation to allow flexibility, we also need to have ways of setting a floor. And I think one of the things that's important to bear in mind with LAUTSI, although when you first read it, it just sounds like they're saying, well, the original panel got it wrong, we recognize there's margin of appreciation, and it looks like margin of appreciation is just being used as a doctrinal cop-out. I don't think that's right. I think that it's a very significant, and I think this is consistent with what Professor Lugato has been saying. I think there is a vital core of what's being protected. And part of it is there's a distinction between acknowledging the place of religion in a culture and imposing the culture on people. I think if you live in a country, you have to be aware that the country has a culture and a history, and people have a right to feel proud of that culture and that history, even if they don't fully adhere to it. I don't think that should be used as an excuse for imposing the religion on other people who may disagree. But I think one of the things that is really significant is that we can learn from each other. When we went through this experience I talked about in Utah, we started realizing that if you were really strict about if you had the fundamentalist secularism that some of the people were trying to press, you started thinking about what would happen in the schools. Could you have music classes in the schools? Imagine music stripped of all religious significance. We tried to think of what was left, and it wasn't the richest part of the music curriculum. We need to be able to acknowledge, but we need to find ways of acknowledging without imposing. And I think some of the things that Professor Ferrari was suggesting this morning about distinguishing between formal contexts and informal contexts is a way of moving in that direction. I think that there are a number of ways that LAUTSI gives us guidance on this issue. It clearly leaves a sufficiently broad margin of appreciation for passive symbols like the crucifix. There's also margin of appreciation to require teachers not to wear religious symbols. So there are other states that are viewing margin of appreciation in different ways. I have to tell you, I have questions about this. One of the problems about LAUTSI is it looks like Christian symbols get protected and Muslim symbols didn't. And I think that's problematic. But it helps a little bit to be able to say we've got different margin of appreciation in different countries, and it's not Europe saying Christians good, Muslims bad. It's that different systems are wrestling with different sets of pressures, and we have to have some margin of appreciation. But we do need some European supervision. That is, we need to make sure that religion isn't being imposed, that to the extent there are symbols in play, that they're used in ways that are even-handed, open, critical, and so on. And I think, read with care, and I have a lot of other factors that will be in my longer paper, but there are a lot of things areas where LAUTSI really does set a floor. One of the worries out there in the Council of Europe is something like the basic Orthodox education classes proposed in Russia. These are being amended and revised because it became very clear fairly quickly that this was just a cover for indoctrination type instruction. And and that's problematic if there aren't adequate opt-outs for people who are not believers. So I think one of the things that LAUTSI really did a good job of wrestling with is, when is it that religious symbols are not really imposing or interfering with people's religion and conscience? When is it fair to say people should have sort of thick enough skins or just be appreciative enough of culture that they recognize that this is not intended as imposition of religion? And I think it strikes a very useful balance. Let me shift to another experience very quickly. Silvio Ferrari, Sophie van Bijsterveld, a number of us in this room were involved in the OSCE project on developing the Toledo guiding principles for teaching about religion in schools. This was an initiative to try to provide guidance for school systems that wanted to do teaching about religion, as opposed to some of the systems that do teaching of religion, but to try and give them some guidance as to perspective as how this could be done in a sensitive way. Now, I'm not going to go into detail on that, except to highlight one part of the experience for me. One of the most fundamental things I learned from that experience is how hard it is to do teaching about religion. How hard it is pedagogically. All too often in our educational systems, that kind of task is sort of farmed out as an... Now, I remember when I first read the German school prayer decision, there was a phrase that said, one of the great things about having religious diversity in the classroom is that with a sensitive teacher, it provides opportunities for integrating the students and teaching people how to live in a pluralistic society. And this was really striking to me because I was reading this at the time when I was also very conscious of U.S. efforts to integrate the United States racially through education. And I thought, how interesting that people are seeing that if you have adequate margin of appreciation and good, sensitive teachers, you can really teach people and give people a positive experience of a pluralistic society. I think we need to be able to encourage that. I think it's very hard. Let me conclude with one final experience, which is, it goes in a way to what was said earlier about finding other ways to recognize religion and religious diversity in legitimate ways. This is the day of my son's high school graduation. I have to tell you, on that day or the day before, there was a lot of litigation going on about whether there could be prayers at graduations in the United States. And ultimately, it at first looked like there couldn't be, but then there were some decisions saying that if the students decided to do it themselves, it was permissible. So some students at my son's high school decided themselves, I hope it was just with themselves, to add some prayers to the program. But I'll tell you what was remarkably moving about this. The final prayer was said in Spanish. Most of us, except for that growing percentage of people in my city who are Spanish speaking, did not understand what was being said literally. There was no translation. We could resonate with what was being said, and in profound ways we were reminded what it is to respect other people and to make room for other people in our midst. And I think we need margin of appreciation with supervision to make sure that that kind of thing happens in better ways in our societies. Thank you.
Thank you, Professor Durham. We do have a very brief time for questions before we break for lunch. And we will have time over lunch and over cocktails back at St. John's later today to continue this conversation and pose more pointed questions to our individual panelists. I'm left with an overarching question that I'm going to articulate but not ask our panelists. And that's really about implementation. How exactly do we implement a margin of error in the context of subsidiarity? How do you decide when to defer to a national approach? For example, if the national approach isn't democratic, or if democratic doesn't meet minimum standards, or in Professor Girolami's view, how exactly do you use social history? I understand the importance of it, but then how do you use it to provide not just an analysis, but an answer to a dilemma requiring a tragic choice? Or in Professor Durham's approach, how exactly, in the context of trying to live with and implement a margin of error in a pluralistic society, decide where the minimum standards should be? I'm not going to pose that question because I think that's going to get us too deep into a long discussion, and perhaps one that our panelists purposely want to avoid. I know Professor Girolami likes to avoid having to give actual answers. But short questions, not long interventions, but short questions from the audience before we take our lunch break. There's a hand in the back.
I can't even respond to that. I can't give an answer to that one either.
Nope.
Hi, this is for Professor Girolami. I'd like for you to
If you could just hold the microphone close to
Sorry,
your mouth.
this is for Professor Girolami. I'd like for you to turn behind you on the wall there. Right. Okay? And I'd like for you to posit that that's the cross, not the simple white cross, but that's the cross that the veterans wanted to pose. And I note that in your list of symbols of cross, you don't include any of the negative connotations that the cross has had. As a Jew, let me tell you what that conveys to me when I see it. Among other things that you mentioned, it conveys the history of genocide and intolerance, the Crusades, the Spanish Inquisition, okay? And none of those things managed to make it onto your list of things that the cross means. And so, to me, if the message is that the veterans want to convey is we want to memorialize the fallen, you don't need a religious symbol to do that. That's a choice that has very negative repercussions for some people. Now, following along with Professor Durham, actually, I'm also thick-skinned enough and living in a predominantly Christian nation, that the cross on the hill doesn't bother me. And so if it provides some sustenance to some people and is important to them for recognizing in their tradition the sacrifices that have been made, I personally don't have a problem with that. But honestly, it bothers me that it seems as if when you recite the characteristics of the religious symbol, you don't seem to acknowledge the negative aspects of it and the way in which non-believers can be tremendously offended and concerned by that.
Oh, so, thank you for your, is this on? Yeah.
Yep.
Thanks for the comment, and I take the point in the 20 minutes that I had. I wasn't able to list all of the meanings, and it's a fair point to say that I didn't list the negative meanings that a cross can have. I was trying at that juncture to list the meanings that the people in favor of the cross in that litigation we're trying to get across. We're trying to express. But I think it is fair to say, and actually in keeping with the clash of values that I described at the beginning of the presentation, to say that the cross can have, and this is maybe perhaps a little bit where I differ from Professor Ferrari, can have multiple reasonable meanings, can convey multiple reasonable meanings. I wouldn't want to go so far as to say that any subjectively experienced meaning is and ought to be legally cognizable, but I do think that historical and a well-developed historical and cultural record can evince certain reasonable meanings, and among those meanings would be some of the meanings that you mentioned as well. So I take that point. I think that's correct. Having said that, I think I disagree with the comment that that they don't need, or the veterans just don't need that cross. And I guess I disagree with the beginning of the comment and agree with the end of the comment, your comment, where you said that they do feel like they need the cross to symbolize and memorialize the fallen. And the bottom line for me is that no single value, no value like neutrality, is going to be able to reconcile that conflict. And in answer to the Dean's challenge, just a quick answer, I think that there won't be a single answer. There will not be a single answer to what it is that the cross represents and what it is that we ought to be trying to inculcate. There will be a range of answers, a range of responses, which will create something like a common law of religious liberty over time, which courts can then rely on as a support for deciding cases one way or another way in reconciling those conflicts.
Sure.
Let me just add something briefly, and it's just for me one of the more impressive comments of what happened in the Salt Lake City Council prayer case that I talked about at the beginning. The City Council won the case, that is, they won the right to have City Council prayer, and then they terminated the practice out of respect for some of the other people. I think one of the ways that this happens, and one of the reasons some margin of appreciation is important, if you've got people who will really work with democratic systems and make them work well. I mean, sometimes democracy is approached as a game that we have to win. But I think the better view is it's an opportunity in which we can learn from each other and find ways to be sensitive to each other. So you have the Bavarian solution that lets the cross stay in the schools except where there's real opposition, and if there's real opposition, then maybe they take it down. I think what's so hard is that these battles have different meanings. I mean, I'm conscious in Germany, for example, that the Constitution says there shall be religious instruction in classes. And you have to understand in the background of that is the Kulturkampf under Bismarck and the Kirchenkampf under Hitler. And so if you say no religion in the classes, it's a continuation of that anti-religious tradition. In the United States, it's been just the opposite. Part of the reason we need margin of appreciation is that the cases about symbols become themselves symbols of reaction to past problems, and they may have very different symbolic meanings in different cultures, and we have to be able to take that into account.
We have had a full morning of intellectual nourishment. I think it's time for some bodily nourishment. So we'll break for lunch. We will reconvene here at 1500 at 3 p.m. And I would ask and make one announcement. I would ask all of the speakers from this morning and from this afternoon to gather right here, right now, before the speakers break for lunch so we can take a group photograph. And to everyone else, see you after lunch.